Hello, respected viewers. This is my English law channel and a bit about criminal law. There's some overarching principles of English law that there has to be various things, forbidden behaviour, so that's an external element, and there has to be an intention to do something against the law. That's the mental element. So something in your mind and something that you actually do. Occasionally, a crime can be committed by not doing something, but we'll come on to that later. So when you're asking if somebody's committed a crime, you must always inquire whether the person accused of a crime has indeed done something which is forbidden by law. You also have to see if that action, which is prohibited by law, was accompanied by an intention to commit a crime. So if there's a forbidden action and there's the mental element, the intention to commit a forbidden act, then put those together and that's a crime. There are some exceptions when the action itself is a crime without any intention to commit it, but we'll come on to those later. So there's the old Latin tag, actus non facit reum nisi mens sit rea, as in the action does not make somebody guilty without the guilty mind. So the actus reus, the guilty act, and the mens rea, the guilty mind. You'll find that in common law. You'll also find that in Roman law. Anyway, we'll go on to more specific examples of this. So the actus reus, that is doing something which you're not allowed to do, and the mens rea is the mind, your mind. Intending to commit a crime, such as being reckless as to whether a crime is being committed. It can be some dishonesty, that could be the criminal mental element. There can be knowledge that something is a crime and so forth. Withholding knowledge occasionally can be a crime. Believing something to be a crime and so forth. Now there are various defences you can offer, because sometimes doing something which is usually a crime would not be a crime in very particular circumstances, because of necessity, because of self-defense, because duress meaning you're forced to do something. So we're talking about the burden of proof. Remember, if it comes to a criminal case, there's the prosecution arguing the defendant is guilty and the defense who argue the defendant is not guilty. So the burden of proof is on the prosecution. It behoves them to demonstrate that the accused did indeed commit a crime. That's where they have to prove it beyond all reasonable doubt, as in there could be a penumbra of doubt. If there's even just a very slight doubt, a court can nonetheless convict somebody. If there's more than a slight doubt, if it's somewhat significant, then they must acquit. That's to say, to declare the defendant to be not guilty, in which case he or she goes free. There was a case called Wilmington and Department of Public Prosecutions in 1935, and the judges in the House of Lords had to ask themselves whether the actus reus was enough, whether that meant the burden who had to prove that killing was an accident. A man had killed another, but he claims it was an accident. Who has to do the proving? So that the burden of the proof that then doesn't pass to that person. Okay, so people are assumed to be innocent until proven guilty. So the prosecutions are ones who have to do the proving in this case, to prove that it wasn't an accident. We have to assume that he's telling the truth when he says that the killing was accidental. It was like less than murder. So this is a defence's offer, and it's up to the prosecution to disprove that defense, to demonstrate that defense is a lie, usually. Now, again, it does get a bit more complicated. So we've seen what the standard of proof is. Okay, well, let's go into more depth on the actus reus, the guilty act. So the actus reus almost always involves behaviour. There are some rare examples when it can be inaction. By doing nothing, you commit a crime, as a parent not feeding your child, for instance, not paying your tax. That doing nothing, the not paying tax, is a crime. Sometimes there's a result crime. You do something which is not in itself illegal, but if it results in injury or something, then it is a crime. Well, I'll come on to particular examples a bit later on. So, what's an act? Well, it could be moving your body, for example, and it usually has to be voluntary because we'll come on to automatism when they're involuntary movements because of unusual situations. So, like you want to kill someone, that could be dropping poison into someone's drink, stabbing, shooting, strangling. These are actions. Sabotaging somebody's motor vehicle to cause them to crash. These are actions that you take which result in death. So, anyway, or for example, there's a case called Hayward in 1908 where somebody simply threatened another and chased that person. The victim then had a heart attack, but that was still held to be murder because it was the threat of violence which actually led to the death. Okay, so you not doing something can't be murder. Okay, failing to save somebody when you could easily save the person's life is not murder. There was another case, Bratty and Attorney General for Northern Ireland, 1961, and Lord Denning had to look into this, and he said that the bodily movement must be of the person's free will. He said no action is punishable if done involuntarily, and it was an involuntary act in this context. So an act done by the muscles without any control of the mind, such as a spasm or reflex action or convulsion, is done by someone who's not conscious of what he's doing. An act done while suffering from concussion or sleepwalking, that's not a crime. Somnambulism, walking around in your sleep, and you accidentally push somebody off a cliff, that wouldn't be murder because you've no control over that. If somebody puts a baby down in the bed beside you when you're asleep, you don't realize that, you roll over and crush the baby, that wouldn't be a crime because you didn't have control over your movements in that situation. If a person whose limbs have a mind of their own and could just fly off in this direction and hit someone resulting in their death, no, that would not be a crime. So, okay, so we've seen what the actus reus is, and we've seen the definition of a crime. Now, as I say, there are some situations where you can commit a crime without actually doing anything. So there's things called situational liability. For instance, being under the influence of alcohol in a public place, as in not a pub or restaurant on the street, that's a crime. Being in a crapulous state whilst in charge of a motorised vehicle or indeed a bicycle, that's a crime. Owning some sort of prohibited canines, that's a crime. Pit bull terrier, for instance. Having your dog dangerously out of control in a public place, that's a crime. It's not a crime if your dog is in your private property. So it was your fault for letting off the lead, but I didn't incite the hound to go and be dangerous out of control. Nonetheless, you are liable. Princess Anne, she was convicted 21 years ago of having a hound out of control in Windsor Great Park. So even though there's no wrongdoing, it's just because of this situation, you didn't take any particular action. Okay, so Elvin 1994 was a case about a man having his hound out of control, and he was found guilty. Possessing certain forbidden items, a firearm without a license, that's a crime. A mace spray, unless you're like authorized as a police officer, that's a crime. Possessing various drugs, blah blah blah. Possessing knives in public beyond a certain length, that's a crime as well. So their omissions, when you do nothing, can be a crime, and usually it's commission, actually doing something, as in hitting somebody or selling drugs or whatever, or burgling. These going out and doing things, commissions, are crimes, but there are a few omissions. By doing nothing, you can be committing a crime. Okay, so anyway, so carry on a little bit more. So criminal liability. There sometimes there's a duty to act, and failure to act can be a crime. And if you were in breach of your duty to act, then this adds up to a crime. So, and your failure to act must be of your own free will, and there must be harm arising from that omission. Okay, supposing the parent has a duty to look after his child, and then the parent fails to act, so that's breaking the duty, and this failure to act must be voluntary, not because he's been kidnapped or something, and then harm must result as in the child is malnourished, because supposing you failed to feed your child, but your child got food for himself or herself, then no crime would have been committed. A result crime depends on the result of the not feeding the child. Okay, so you can commit here a crime by omission, by failing to do something. Okay, what else? There was a case called R and Dunn, where a man in 2015 was accused of indecent assault against a minor 15-year-old girl, getting her to touch his membrum virile. And this was said to be indecent assault. Actually, it wasn't, because he wasn't doing anything. He just said for her to do that. He had committed a crime, but that was inciting a minor to engage in a sexual act. Okay, so we see legal duties to act. It's parents to children usually, sometimes doctors and nurses to their patients, teachers to their pupils, or police officers to the general public sometimes. These people have a statutory duty to act. But it's not reciprocal. So though parents have to act towards their children, children don't have to act towards their parents, even their elderly, frail parents. So there's no mutuality there. So an adult child is not obliged to save his mother or father. Okay, maybe unfair, but that is the law. You don't have a duty to save members of the general public. Sir James Fitzjames Stephen said this in his Digest of Criminal Law, 1887, a very distinguished jurist, father of J.K. Stephen, Jack the Ripper murder suspect, his son, although his son is actually certainly not guilty. Well, anyway, what did Stephen say? If A sees B drowning and is able to save him held out his hand, if A abstains from doing so in order that B may be drowned, and B indeed is drowned, A has not committed an offence. So, a member of the public, I don't have to save somebody else. Even my friend, my deadly enemy, I'm under no obligation to actually save that person. Perhaps seems curious, but that indeed is the law. Okay, so then there was a case called Airedale NHS Trust and Bland, 1993, about a Hillsborough disaster victim. This young man, Tony Bland, he'd been asphyxiated at this disaster at a football match. His lungs crushed. His brain was largely dead. The brain stem was functioning, and he was there on a life support machine in hospital 4 years later. Was it acceptable for the doctors to turn off his life support machine, which would lead to his death? Because that is an action. Anyway, it was eventually found that it is acceptable to turn it off because they were simply inflating a corpse effectively. So I wonder whether that was the right decision. Okay, so anyway, if you have a duty to act and you fail to act, and you could have acted, but by your own free will you chose not to, then that can be a crime. It can be like some sort of negligence. So, and remember, it's got to be voluntary failure to act, not because you were in prison and you couldn't look after your child, for instance. So, and remember, harm must arise. If you're in breach of your duty to act and no harm comes from that, then that's not a crime. Okay, so it was Morby, 1882. This is a case where a child suffered smallpox, and his father didn't bother calling a doctor or nurse or anything. So then he was charged with manslaughter, as in, which is causing the death of someone, but it's not as bad as murder. Could be accidental. Anyway, eventually he was acquitted on appeal on the basis that the baby would probably have died anyway from another condition. Anyway, might seem strange. So anyway, let's look on to what theft is all about. Right? You could look at the Theft Act, for example. It says a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it, and thief and steal shall be construed accordingly. So that's the Theft Act 1968. A person subject to the exemption of this act, it is an offence for a person to have in his possession or to purchase or acquire a firearm to which this section applies without holding a firearm certificate in force at the time or otherwise as authorised by such a certificate. So curiously, in the Theft Act, they put in this rule about firearms. Firearms are allowed in the United Kingdom, certain categories, for people not in the police, the armed forces, but only if they have a valid certificate, and the police can confiscate that firearm if they believe you're dangerous. They don't have to prove you're dangerous. If, for example, you don't have a lockable cabinet, if you acknowledge to them that somebody else knows what the key to that cabinet is. A man told the police, actually, my mother knows what that key is. The police took away his gun on the basis only he must know what the key is. If his mother knows what the key is, she's got access to the gun, she could go shooting people, and they never gave her a firearm certificate, so they didn't say that she was safe to have it. Okay, so that's just a little bit about mens rea. Okay, goodbye then, toodaloo.